and now a government IP policy analyst?
Uh,
I
you know,
mean,
engineering is
do they-
also art, you know. It's art, you know.
Engineering is
Science is
art.
also art, you know. It's expression and everything. That's why I can easily relate to inventors. I know they're polite. It's their expression. Only it's in a different field. No, unlike music, of course.
And unlike music. But is our government, or at least our country, giving enough support for our Filipino scientists?
We have lost now. We have lost, but I think the inventors giving them incentives. I think the OST is helping the inventors to file patents. They have this bureau there to help them and even assist them in the filing fees, I think.
With the filing fees for patents?
Yeah.
Okay. So you have partnerships with
Yeah, with
other
UST.
government, with the
The
DOST in
UST.
particular. Wait, how long does it take for a patent application to get registered?
Well, for an invention patent, it takes about 3 to 4 years.
3 to 4
Yeah,
years.
it's standard in all countries, not only in
Okay.
the Philippines.
Okay.
Because you have this 18-month period to wait. So when you file a patent application for an invention, the 18-month period is mandatory. So it's confidential for 18 months. So that is so after that you have about 18 months another. It depends. It depends on the technology. It depends on the inventor also.
And during this time that the patent application is under process, can you start, for example, looking for an investor and start manufacturing your invention?
Because we have this, since the inception of the new law, that's RA 8293, we adopted the first to file system. So upon filing your application, you're already protected. So your protection starts from the filing date.
From the filing.
Not like before 1998, it's from the date of grant. So it's
You have to wait for your registration.
But
Bago
this
ka
time when you
magkahan.
file, you're already protected. Your
Para di
protection
pala.
starts from the date of filing.
Para di pala sa trademarks,
Yeah,
from the first to file, kasi yung unang mag-file. Pero, are there instances when fraudulent yung nagpa-file? Like, for example, in trademarks, we were discussing last week na there are some people who register trademarks, pre-register them kasi first to file, and then later on, when the true owner comes in and realizes that someone registered the trademark ahead of time, pinapakancel na lang or binabayaran na lang para i-turn over yung registration. Does that also happen in patents? Na
So it's not when I was an examiner, I never
it's not a problem
during
naman
my time.
in patents na invention ko, ire-register
I think
mo.
mas okay pa
ganyan.
yung system ngayon kasi first come first serve eh.
First
So
come,
may
first
date
serve.
ka first to file ka. Unlike before, syempre, before you have to wait for the grant. So it's a question of inventorship before eh. But this time, who files first he's presumed to be the inventor.
So what do you look for again when you file kasi there are inventions that get rejected for patent registration, I'm sure. So it has to be new, meaning it has not been published before.
Yes.
And it's not part of prior art. And it has to be industrially applicable, meaning pwede mong i-manufacture ng maramihan. And also it must involve solution.
Step.
Yeah, in an
Inventive
inventive
step.
step. So solution siya to an existing problem. If one of those elements are missing in my invention, it can be rejected.
It can be rejected on those grounds.
On those grounds.
So in patent examination, the examiner conducts a prior art search from the different databases in the world, no? So based on the prior patents, no? So based on those patents, the examiner will determine the closest reference to his invention. So so the invention must hurdle the first hurdle novelty. So for example, I have an invention of a table. So there are two elements. We have the tabletop and the
base.
The base.
And the base.
So I have to look to determine what is new in the table. So for example, what is new is that this one can be detached. So it can easily be transported or placed in different places. No? So for example, that is the invention. So I have to look for similar
Inventions all over the world.
Having that the same feature of having a detachable
Top.
So,
Okay, so in the IPO, the patent examiners are not only scientists or licensed engineers, they also have access to databases
yes, they have access
of inventions across the world.
to determine the prior art.
To determine prior art. Are our inventions also registered with other countries such that if they conduct their prior art, makikita nila what are invented here?
Yes, of course.
Okay, so there's a
So our
cross-reference.
database already also available in other countries. So they can use our database as part of their search for prior art.
Pero is that database open to the public or just the patent examiners?
It's for the public.
For the public. So if anyone out there wants to file for a patent application, they have to first make their own research.
Basically, that's the first thing they have to do, no?
First
They
thing
have to search for their invention if there are similar inventions already. So they won't waste their time and effort in filing the application.
In filing an application.
Kasi baka meron na eh.
Oo, yun din ang problema sa trademarks. Baka meron na. So they have to, where can they look for the patent database? Can you give them
in
the
our website, in the library, no? And one point for patent, for example, one more purpose for the patent search is, for example, I have an invention, then I saw a similar patent, I can go around that one. No? Hindi porke may kapareho na, hindi na pwede. So I can go around that patent. So in writing the claims and description, I can really identify what is new in my invention. No? Pero syempre, kung parehong-pareho na,
you will deny that. Pero yung pagsusulat ng claims, is that something that inventors need a legal assistance for, or is that something that they can call the IPO for assistance?
In time, they can it can be learned, no? Through reading patents also, patent documents, to attending seminars sponsored by the IPO on how to draft claims. It will take time. It's not an easy task to drafting claims.
Obviously, it's a discipline.
It's a discipline, and it's the very heart of your invention, protection of the invention. It states there what is your invention, what is not your invention, and what is your invention.
Is it difficult to describe inventions in that way? I mean, in drafting a statement of claims, do scientists find it difficult to transcribe it into words?
I mean, they know they have special fields, no? So, for example, the skill chemists, they know the terms.
Technical
terms.
Very technical.
It's a matter. It's an art.
The writing is
an art.
It's an art. Because you don't want to overdo it.
Overdo it, and the examiner will reject it for being too broad.
Oh, see.
For example, if you say this, if you want to claim this one, you say, if you want to claim that, you can claim it as a table having a tabletop and a base. But if you wanted to make it broader, a table having a means, a table having a tabletop and a means to support the tabletop.
That's not broad.
So that means it's broad.
It's still broad.
It means you can. So it depends on how to. It's an art of drafting claims. No?
Para palang bar exam.
It's very important for the inventor, no, because it's his protection.
I think patent drafting is it's a technical form of writing by which you can pass or fail your patent registration. The IPO is welcome to assist them, or they're welcome to get a lawyer to draft the claims.
That's why the IPO is also, I think it's reaching out to teach inventors how to draft patent claims. It'll take some time, It's practice.
Okay, what are the other efforts of the Intellectual Property Office to protect our scientists and their inventions? Aside from assisting them with patent drafting, how about our scientists to go abroad, for example?
Well, I think there are programs, no? There are programs. And I think most of our scientists, they have awards abroad, It's WIPO awards, innovative awards from WIPO. They have scientists who already have won these awards from abroad.
Okay, you were telling us earlier that you are revising the rules for rules and regulations.
Yes, the rules and regulations for
patents. Okay, what needs to be revised, and why are you?
Actually, we're streamlining the procedure to make it more faster.
That's what the stakeholders want, of course.
More faster and more easier for them to understand. In the process, more easier for them to go with, no.
I see.
But there are provisions that are not clear.
Like, what, for example?
For example, provisions on submitting third-party observations.
What's that? What's a third-party observation?
So when your patent has been published, during that, after 18 months, your patent will be published, then third parties can file observations, comments that your patent is not new, everything. So in this new law, in this new IRR, we devised a more specific procedure to go about.
So you want it, more stakeholder friendly, more user friendly for our inventors and stakeholders.
Yes, and during examination, the examination period should be more transparent to our stakeholders. No, para malaman nila na iba na to, may inform sila na wag mo na bigyan ng patent dahil meron ng ito, meron ng existing. So they're given a chance to participate in the examination of the patent.
Okay. Earlier, you were saying may tatlong types of inventions, patents, what was the other
So
one?
that's invention, patents. Invention, you call them patents. Then utility models, then industrial designs.
Yeah, for utility models, ano ulit yung mga criteria for
So for a
registration?
patent, start with the patent, it must be new, it must have inventive step, and it must be industrially applicable. For utility model, it must be new and it must be industrially applicable. There's no need for an inventive step.
No need for inventive step. So if you create, for example, invent furniture, can that be,
If it's
can that
new,
fall under as
if it's new.
industrially, inventive,
Utility model.
Yes, utility
And
model.
of course, when you file a patent, it doesn't pass that inventive step, you can always convert your application into a utility model.
Okay, at what point will you know?
During dependency.
During dependency.
So
You won't be advised to instead convert
you will be advised of the prior art.
of the prior art.
So your patent application will be published together with a search report given by the IPO. Then based on the search report, you can see that if it's not patentable, as an invention, you can easily convert it to a utility model. So you decide.
You decide what sort of
If you want to go
registration you want.
If you want to push to as a patent
utility
or
model.
convert it to a utility model, you decide based on the prior art that the IPO will be giving you.
Okay, Engineer Negre, why don't you invite everyone out there who has an invention to first file for a patent, apply for a patent, that way they get protected, and also what are the benefits of being registered as opposed to not registering your invention?
Well, inimbitahan ko po yung mga kababayan natin sa dyan, mga inventor po na mag-file po kayo ng patents nyo. No? Kung may mga technologies kayo na bago, i-file nyo po. Huwag kayong matakot mag-file. Kasi mas mahirap po kasi kung hindi mo final at kinopya ng iba, baka yung kumopya yung pa yung mag-file. Sooner or later, pipigilin niya kayo. So, I'm encouraging all the inventors there to file their patents in the IPO and get protection. Kasi it's be more difficult if you are selling your technology but you have no protection. If somebody copies the technology, you can never go stop them from copying your technology if you don't have a patent protection.
So, inventors have to protect themselves by registration. Otherwise, wala kang habol kapag kinopya na yung invention mo. Yes, tama yan. Again, ladies and gentlemen, thank you for joining us tonight here on the show Intellectual Property, right here on GNN, where we bring you intelligent programming. Again, for those businessmen or inventors who have pending cases with the Intellectual Property Office, as our guest, Ms. Quipit, mentioned earlier, all cases are now subject to mandatory mediation. Do avail of that and have confidence in the system that this will entail shorter period of time with more success results. As for those of you entrepreneurs and inventors, do register your inventions with the Intellectual Property Office. Their website is www.ipopphil.gov.ph. They're also on Facebook. Do like them, IP Philippines. And again, we'd like to thank the Intellectual Property Office of the Philippines for bringing us this show and the World Intellectual Property Organization. Join us next week for another informative session on intellectual property with me, Attorney Sara Suguitan. Good night and happy weekend.